When should you go to family court in Ontario to protect your money, assets, and family law rights? Hi, my name is Thomas O'Malley, and I'm an experienced family lawyer in Durham Region and the GTA. When you are getting separated or divorced, you're naturally facing a tough time in your life. Who needs the hassle of fighting their ex-spouse in family court at this difficult time in your life? Generally, you should first try to negotiate a separation agreement with your spouse before ever consider going to family court. Take the time to discuss your separation, divorce, or family law case in detail with your lawyer to see if you can negotiate a separation agreement to avoid family court in the first place. However, you face certain situations in which family court is inevitable. For example, your spouse could take you to family court to deal with the legal issues in your separation or divorce. This is usually not a good situation at all when you have a higher income than your spouse, or your net worth is higher than your spouse's net worth. In these situations, you often get a better deal with your spouse by staying out of court than trying to settle your issues after your spouse has started the court process. You can reduce the risk of your spouse taking you to court by giving your spouse full financial disclosure with the supporting documents in a timely manner from the start of your separation. However, you might have to take your spouse to court when they are acting unreasonably. For example, your spouse might restrict or limit your access to your younger children. When you have a close relationship with your kids, you should be able to see them on a regular basis. In fact, you should be able to see them regularly on a weekly basis. Your spouse in this situation is probably improperly limiting your access to your kids. Your spouse could refuse, for example, to deal with the property issues in your case. For instance, your spouse could refuse to sell the matrimonial home even though they cannot afford to buy out your interest in the home. You might have to get a court order to force the sale of the home, since your spouse will not agree to the sale. Your spouse could ask for an unreasonable amount of spousal support. That's another example. Your lawyer can certainly tell you what a reasonable amount of spousal support should be based on your income and your spouse's income and the length of your relationship or your marriage. You must carefully weigh out the advantages and disadvantages of taking your spouse to family court. Your family lawyer should provide you with excellent guidance and advice on whether it makes sense for you to go to court based on the facts of your particular case. Even if you decide to take your spouse to family court, you can often settle your case during the family court process. Many spouses in court come to realize that what they are seeking in their separation divorce is not that reasonable based on Ontario family law after they hear the comments of the judge in their case. In fact, fortunately, most cases settle in family court during the court process. I've seen many unreasonable and difficult spouses on the other side of my clients' cases get reasonable really quickly when they hear the same message about the strength of their case from their own lawyer and the judge in the case. If you have any questions about your separation, divorce, or family law case, and you'd like our help, there's a few ways to contact our office. You can leave a message on my Facebook Law Office page, visit my website at www.canadiandivorcelegaladvice.com, or call me directly at 905-434-8837. You can also join my free Facebook group. All you do is go to the top search bar on Facebook and put in Durham Region Separation and Divorce Support Group. You'll find it, and please join. Thanks for watching this video, and have a great day.